The Honorable Court of Appeals of Tennessee is now in session.
Good morning and welcome to the Zoom argument in the Tennessee Court of Appeals. We appreciate both the attorneys and your clients agreeing to participate with us in this process. It is the effort of the appellate courts of the state of Tennessee to try to continue to conduct business in as safe a manner as possible during this pandemic, and we certainly appreciate both of you being here and agreeing to participate with us. Before we get started, I want to introduce the panel for this morning. First of all, we have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. Both of you are experienced practitioners and you know the process, but each side will have 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you've introduced yourself and before you begin your oral argument. You may reserve up to 5 minutes of time for rebuttal. We want to thank Mr. Hibner and his staff for being the quarterback of all this, for handling all the procedural details. They've done an excellent job and we appreciate that, as well as the AOC technology staff who make this all run for us. Left up to us, we'd be lost. So we certainly appreciate all of them. Mr. Hibner, if you would call the case, please.
Crystal Spearman versus Shelby County Board of Education and Shelby County Schools.
All right, we'll hear from the appellant.
Thank you, Your Honor, and may it please the court, Andre Mathis of the Shelby County Bar, and I represent the appellate Shelby County Board of Education and Shelby County Schools, which I'll be referring to as SCBE. I would like to reserve 5 minutes for rebuttal.
All right, sir, you may proceed.
Thank you, Your Honor. This court should reverse the trial court's order denying SCBE's motion for involuntary dismissal and the order of judgment entered in plaintiff's favor. This is a GTLA case that arises from the incident that took place at Jeter Middle School in Memphis, Tennessee. The facts of the case are pretty much undisputed. The minor plaintiff was a 6th grade 12-year-old student at Jeter Middle School. Marcus Mosby was a teacher assistant who also coached basketball and track and field for the school. And the incident happened on January 27th of 2016. Mr. Mosby was conducting tryouts for track and field, and one of the sports that they were trying out for was shot put. During the shot put tryout, Mr. Mosby allowed any student that wanted to participate to throw the shot put, and he instructed, all the other students to stand behind whoever was throwing the shot put. Mr. Mosby stood on the opposite side of the field. He also had a couple of students on the opposite side of the field with him. Mr. Mosby would retrieve the shot put after it was thrown by the students, and then one of the students that was on the side of the field with him would roll it back to the next student to try out. After all the students had thrown the shot put, Mr. Mosby was going to show them how to do the shot put the proper way because they were all doing it wrong. So Mr. Mosby, while he was still on the opposite side of the field facing the other students, got the shot put, told the students to move back, and then proceeded to throw the shot put in their direction, 35 to 40 feet in their direction. And the minor plaintiff was struck and injured. Now, we've raised several issues in our brief, but I intend to primarily focus on the sovereign immunity issue. And as we all know, the GTLA removes the governmental entity's sovereign immunity if an action is brought in strict compliance with the GTLA. And under Tennessee law, the GTLA is confined to its express terms and is construed in favor of the sovereign. Here, the plaintiffs brought this action pursuant to TCA 292205. And under that statute, SCBE's immunity is removed for injuries caused by a negligent act or omission committed by an SCBE employee. And so confining the GTLA to its express terms, this means that if the employee acted more than negligent or less than negligent, SCBE's immunity is not removed. And the trial evidence here shows that Mr. Mosby's conduct was more than negligent. And in fact, it shows that Mr. Mosby's conduct could be classified as intentional, reckless, or grossly negligent. And now to start with discussing whether—
Did the trial court make a finding about that?
Yes, Your Honor. The trial court found that Mr. Mosby did not act intentionally, did not act recklessly or grossly negligent. The trial court found that Mr. Mosby's conduct was mere negligence.
Okay, and in making that allegation, I'm not sure I can articulate what troubles me about that, but it's my understanding that only the Shelby County, well, the government was sued, whether Shelby County Schools. Mr. Mosby was not sued individually, is that correct?
That's correct, Your Honor.
Okay. And did, in your representation, collective representation of the school system, I'm assuming you're representing Mr. Mosby as well, aren't you?
We did not represent Mr. Mosby in this action for a couple of reasons.
Isn't he an employee of the school system and an agent of the school system, alleged to have done wrong?
He was an employee at the time. He was not, at the time of the incident, he's obviously an employee. He was not an employee at the time that the lawsuit was brought, and at no point in time did we represent Mr. Mosby during the proceedings.
Well, why, if he was an employee, why weren't you representing it? I mean, you're representing the collective school system, everybody who's alleged to have done wrong. I'm not being critical, but it seems like to me the school system is throwing Mr. Mosby under the bus, so to speak.
Well, I wouldn't put it that way, Your Honor, that we're throwing him under the bus, but we do have to look at the conduct as it is. And obviously, we take the position that his conduct was, intentional, reckless, or grossly negligent. And so, with allegations like that, it would be difficult for Shelby County Schools to represent Mr. Mosby. The fact of the matter is, as Your Honor pointed out,
but aren't you representing him until you say we're not representing him because he's the employee of the school system and he's the person accused of doing the wrong that relates back to the school system?
I will have to respectfully disagree. At no point did we represent him. At no point did we represent to anyone, including, the plaintiff's counsel that we represented Mr. Mosby. He was not represented by Shelby County Schools in this matter.
Okay.
Mr. Mathis, have you maintained, or has your client maintained that position throughout the entire litigation that Mr. Mosby acted more than negligently?
This was, so we denied the allegations in the complaint. This was an issue that was raised at trial. As it relates to, I don't think there was any pleading where we said that he acted intentionally, recklessly, knowingly. But as it relates to that, when we talk about sovereign immunity, the burden is on the plaintiffs to show that immunity is removed. What the case law says, and specifically City of Laverne, states that immunity is not a defense. And to the extent it is a defense, it's not a waivable defense because it goes to the subject matter jurisdiction of the court.
Thank you.
Thank you, Your Honor. And I'll start by discussing whether Mr. Mosby's conduct was intentional or constituted the intentional torts of assault and battery. The trial court found that Mr. Mosby did not act intentionally because he didn't have the intent to injure or frighten the minor plaintiff. And the plaintiff take it a step further and argue that there must be an intent to injure or an evil motive. But simply put, the law does not require an intent to injure or an evil motive for a person to act intentionally or commit the torts of assault and battery. Under Tennessee case law and statutory law, a person acts intentionally if he intentionally engaged in the conduct or intended to cause the result. And when we talk specifically about battery, this court has defined a battery as an intentional act committed that results in harmful conduct. Here, Mr. Mosby intended to engage in the conduct of throwing the shot put in the direction of the student. There's no dispute that Mr. Mosby didn't intend to injure the minor plaintiff or anyone else.
Let me ask you a question following up on what Judge McGee asked. So you never asserted in any pleadings that Mr. Mosby's actions were gross, with some kind of gross recklessness or some intentional conduct. Is that right?
That's correct, Your Honor.
Okay, so this comes up at trial, and I assume that this testimony comes in and nobody objects.
Yes, there was no objection to Mr. Mosby's testimony.
So Mr. Mosby testifies. I assume he's there and he testifies.
Yes, Your Honor.
Okay, and was Mr. Mosby aware that you were going to assert these claims against him at that time?
No, Your Honor, we did not communicate. Again, we take the position that we didn't represent Mr. Mosby. We did not communicate that to Mr. Mosby. Mr. Mosby was a witness that was called by the plaintiffs at trial.
Okay.
Thank you. And going back into talking about the intent here, that Mr. Mosby's testimony was undisputed. He testified that he threw the shot put 35 to 40 feet in the direction of the students, and that the shot put went exactly where he wanted it to go. I think the Hughes decision is a great example of a case where there's no intent to injure and no evil motive. And in that particular GTLA case, an employee was driving the truck and revved the engine, pretending like he was going to run into the plaintiff. He was either engaged in horseplay or he was trying to scare the plaintiff. The Tennessee Supreme Court found that the driver committed the intentional act of assault and found that the governmental entity's immunity was not removed in that case, and instead the plaintiff in that particular case had to proceed against the driver. And I see that I'm out of time, Your Honor.
You are. All right, let's hear from the appellee.
Good morning. May it please the court. My name is Derek Fairchilds of the Memphis Bar, and I represent Crystal Spearman on behalf of her minor son, Kenji Lewis. This was a trial by ambush. The appellant spent 3 years blaming Kenji for causing this incident and denying that their employee, Mr. Mosby, did anything wrong at all. And then at the trial, as Judge Stafford mentioned, Mr. Mosby was really thrown under the bus. They completely changed their position and filed the motion to dismiss, claiming that Mr. Mosby was reckless, that his actions were intentional, basically completely the opposite of what they had been doing for the 3 years prior to that. The law doesn't allow that type of legal maneuver. There's several reasons. The first is Rule 803.
Did you object to that?
Yes, Judge. I made an oral objection at the time the motion was filed, and argued pretty strongly against it. The trial judge, who was fairly new at the time, she wanted to take some time to have the parties brief the issues and then do an oral argument later on. So the trial was basically postponed for a couple of months while we briefed those issues. But
the trial court ruled that those allegations could come in, I assume?
Yes, so the judge did not focus on the procedural and equitable issues that I think should have stopped that argument from ever being made. She actually went to the merits of the motion to dismiss of the, was this a negligent act or an intentional tort, and ultimately found that it was a negligent act. But my position is, and this is what I told the trial court as well, is that I don't think she ever should have gotten to that decision of whether it's a negligent act or intentional tort, because Rule 803 of the Rules of Civil Procedure, that requires that affirmative defenses such as comparative fault be raised in the answer. And if they're not raised in the answer, they're waived. They denied all allegations of negligence against Mr. Mosby in the answer. And then, of course, later on at the trial, tried to throw him under the bus and claim that he acted recklessly and intentionally. Rule 803 is designed specifically to prevent trial by ambush. That's the rule that prevents this type of thing from happening. And it should have prevented it in this case. But then there's also judicial estoppel, Your Honors, which that's where a party takes a position completely contradictory to one previously assumed. That typically deals with oaths. In this case, the appellants made several statements under oath that they then later repudiated with their motion to dismiss. In response to interrogatories, all of which were signed under oath by the appellants, when asked if there were any other defendants that should be named in the lawsuit to comport with the allegations in the complaint, the appellants responded no. And if they actually felt that Mr. Mosby had committed an intentional assault or acted recklessly, they should have responded yes. Of course, they didn't do that. And then in the motion to dismiss, completely contradicted their prior statement under oath and claimed that he committed an intentional act. Interrogatory number 11, they swore under oath that this incident was caused by Kenji not following instructions. They provided an exculpatory statement on behalf of Mr. Mosby, didn't indicate anything at all that would make you think that they thought Mr. Mosby had committed an intentional act. And of course, in the motion to dismiss, they completely contradicted that sworn statement. The third sworn statement that I want to point your attention to is interrogatory number 24, where they were asked if there were any safety rules or guidelines that could have prevented this injury from happening, and they responded no. And now in the motion to dismiss and before Your Honors, they claim that not only was there a safety rule that all students should be behind the person throwing, but that Mr. Mosby knew the rule and that he intentionally and recklessly violated that rule. And so again, they have completely changed their position from where, the statements that they had made under oath. The third reason why the trial court shouldn't even have considered this argument is equitable estoppel. And equitable estoppel is when a party attempts to gain an unfair advantage by maintaining inconsistent legal positions. In this case, the conduct of filing the answer, not alleging any fault against Mr. Mosby, filing those sworn responses to interrogatories, not mentioning any fault against Mr. Mosby, that is a false misrepresentation of the facts as they were known at that time. My client, the appellee, relied upon those statements by not amending her lawsuit to bring in the employee, Mr. Mosby. As the court knows, under the GTLA and negligence actions, suit cannot be brought against a governmental employee. And my client, following the law, did not file suit against the governmental employee. Had the appellants then in their answer said, well, we think Mr. Mosby committed an intentional tort or acted recklessly, I would have taken that opportunity on behalf of my client pursuant to TCA 20-1-119, amended the complaint to bring Mr. Mosby into the lawsuit. So my client relied to her detriment on the misstatements of fact that were made by the appellants. The appellants have pointed out that we had an opportunity to gain knowledge of what the true facts were, but I'd like Your Honors to keep in mind that at the time those material misstatements were made, there was a vast disparity of knowledge between my client, the appellee, and the appellants. My client was relying on statements from her 12-year-old son who had just sustained a brain injury, whereas the appellants had the opportunity to speak with the only adult who was present, Mr. Mosby. They took his statement. They took the statements of other children. They had a wealth of knowledge. And yet, despite that wealth of knowledge, they made these misstatements that Mr. Mosby was not at fault. Now, if Your Honors get to if you feel like the appellants have cleared those three hurdles, 803, judicial estoppel, and equitable estoppel, then we actually get to the issue of was this conduct negligent or was it intentional? The trial court did decide this was negligent conduct, and thus that decision is entitled to a presumption of correctness. It appears what the appellants have said in their brief is that all intentional conduct that leads to an injury is an intentional tort. That's simply just not correct. I put a few examples in my brief. Everything we do in life is intentional. If you intend to drive down the road towards a red light and you see a car coming up in front of you, if you rear end that car, it is not necessarily an intentional tort. You could have misjudged how the distance between the cars or your speed or the road conditions. Just like with a doctor operating on a patient, if he nicks an artery, that's not necessarily an intentional tort. That doesn't mean that there was an intent to injure. An engineer that builds a product that later injures someone. Yes, the product was intentionally designed in that fashion, but that's not an intentional tort. And so there's a plethora of examples that I could go through, but not every single intentional act that leads to an injury is an intentional tort. If we look at the allegation of intentional assault, what Mr. Mosby intended to do was to throw the ball, just demonstrate the throw, but have it land short of where the children were. This is evidenced by the actions that he took. He asked the students to move back multiple times. He himself moved further away from the students. He testified he did not throw the shot put ball with all of his strength. You can see the intent of what he's doing. He's trying to make sure the ball lands short of where those students are. There was no intent to injure. There was no intent to scare. There was no intent to throw the ball at Kenji. Now, if we move on to recklessness, that's where you're aware of a risk, but you consciously disregard it. Mr. Mosby, again, he's obviously aware that there's a risk, but he takes those actions to lessen that risk. And so reckless in my mind would be if Mr. Mosby hadn't taken any of those steps and just thrown the ball into the group of children, into the middle of the group of children. That's reckless, just like throwing a firecracker into a crowd or shooting a gun into a crowd. You may not have to have the intent to injure, but by doing that, the probability of injury is so high that it would be considered reckless. In this case, Mr. Mosby again took several steps to minimize the risk to those children. And in his mind, I'm sure he thought there was little to no risk of this occurring. You also, when you deal with recklessness, you have to view the circumstances from the accused standpoint. And so just briefly, I'd like to remind your honors that this is the only adult dealing with 30 or 40 middle school age kids. So not only does he have the job of coaching this team, but he has the incredibly difficult job of controlling and supervising 30 to 40 children. So he's in an adverse situation to begin with. And then if you look at the fact that he had no training from the defendants, that was undisputed in the sport of shot put. He had almost no experience with the sport of shot put. When you take those things into account, the circumstances from his perspective, this is not a gross deviation of the standard of care. Obviously, we believe it is a deviation, but not a gross deviation. The appellants have quoted in their brief a couple of statements that Mr. Mosby made at trial. At trial, he agreed that the ball should only be thrown when everybody is standing behind the thrower. That's something that Mr. Mosby learned during the appellant's investigation of this incident. He did not know that at the time of the actual incident. And you have to keep in mind, so he didn't know it at the time. And then also at the trial, Mr. Mosby was being very remorseful, apologetic, contrite. He had 3 years to think about this and think about his actions and was truly sorry for what he had done. Judges, I did bring up an issue on appeal that I'd like to get to quickly, and that's The amount of the damages, I do feel like the trial court erred by awarding damages in the amount of $200,000. I think the evidence preponderates against that. This was a fractured skull that required a major operation, a craniotomy, resulted in brain damage that was verified on multiple CAT scans, that resulted in disfigurement, scarring, increased risk in psychiatric problems. And to hear that the trial court state that not much weight was given to the brain damage was really kind of surprising in my opinion. And I feel like the evidence preponderates against that award of $200,000. I also feel like I'm not sure if the trial court considered the proper measure of damages. I don't think all elements of damage were considered here. If you look at the transcript, volume 4, page 530, the court lists the elements of damages that she was considering and then proceeds to talk about those elements. Conspicuously absent from that list was permanent injury and disfigurement or scarring. Those are separate elements of damages that I'm not sure the trial court considered. The trial court did mention the scar at one point during her ruling, but it almost looked as if it was support for the claim for pain and suffering and loss of enjoyment of life, not as a separate element, which is required under the law. And so what the appellee would ask is that the damages award be increased to the maximum allowed under the law. If your honors don't have any questions, that's all I have for you today.
All right, sir. Thank you very much. We'll
Thank you.
hear the rebuttal of the appellant. I think you're muted, Mr. Mathis.
I'm sorry. Thank you. Thank you, Your Honor. I'll pick up where the plaintiff left off, talking about damages. I pointed out in my reply brief that the trial judge went through all of the different elements of damages. As it relates to the permanent injury, the trial judge simply stated that she didn't give much weight to it because the minor plaintiff went back to doing physical sports such as football and basketball shortly after this incident took place. And she went through all of the elements of damages there. Another thing that the plaintiff mentioned was that talking about the standard of review, and the plaintiff argued that the finding of negligence was entitled to a presumption of correctness, and that's simply not accurate. This is a de novo review on the record. The facts are entitled to a presumption of correctness, but this is a de novo review. And the plaintiff talked a lot about the recklessness argument. What the plaintiff left out of the argument is in their complaint, they alleged that Mr. Mosby acted recklessly. Now, obviously, they're trying to walk away from that allegation at this point. So in addition to arguing that he acted negligent, alleging that he acted negligently, they allege that he acted recklessly. And the evidence shows that. I believe the Doe Court definition of recklessness is pretty applicable here. And a reckless actor doesn't intentionally harm, but he intentionally runs a serious risk with no good reason. And that's what Mr. Mosby did here by throwing the shot put in the direction of the student. As I mentioned during my initial argument, Mr. Mosby testified that the shot put went exactly where he wanted it to go, and that there were 30 to 40 students approximately 35 to 40 feet away from him, and that's where he threw the shot put. He obviously knew that there was a risk of doing so because when the kids were throwing the shot put in his direction, he would have his students roll it back to the students. And he will also make sure that the students were standing behind the other students. So he obviously was aware of the risk of throwing the shot put and ignored that risk when he decided to throw the shot put in their direction. When we talk about the various arguments that the plaintiffs have made as to why the court shouldn't have considered SCVE's motion for involuntary dismissal, none of those arguments apply here. For judicial estoppel to apply, SCVE would have had to contradict a sworn statement that it made with another sworn statement. that simply didn't take place. The plaintiff brought up various interrogatories. Those are sworn statements, but they didn't bring up any other sworn statement that SCBE offered to contradict those sworn statements. And another argument that plaintiffs make is that, we place all of the blame on Mr. Mosby. Well, we also had a comparative fault assertion against the minor plaintiffs. The trial court found that we didn't overcome the presumption, but we did allege, and we believe we showed that the minor plaintiffs assumed the risk by participating in that activity. So we asserted comparative fault, but we also asserted our immunity. And I also want to point out that in our complaint, we allege an immunity defense. So this isn't a situation where there was simply no allegation. We raised that defense in our answer. And what the city of Laverne case states that even if we did raise that as an affirmative defense, immunity is not an affirmative defense. It's something that the plaintiffs had to prove that our immunity was removed. And they simply weren't able to do that because the evidence showed that Mr. Mosby acted intentionally or recklessly, or at the very least, grossly negligently. Equitable estoppel also doesn't apply here. The law is clear that even if there's a situation where we change our legal argument, that's not what equitable estoppel applies to. It applies to situations where we conceal facts or conceal evidence. All of the evidence that we're relying on is Mr. Mosby's own testimony. We didn't conceal any evidence or testimony as it relates to Mr. Mosby. The plaintiffs had an opportunity to depose Mr. Mosby, and in fact, Mr. Mosby was their witness. He wasn't our witness. And their argument about the affirmative defense doesn't apply as well. So for those reasons, we ask that Your Honor reverse the trial court's decision. Thank you.
Thank you, counsel. We'll attempt to get you an opinion as quickly as possible. We again appreciate your participation in this process. I want to again thank Mr. Hibner and his staff for putting this all together, as well as the AOC staff. Mr. Hibner, if you would recess court until the call of the docket this afternoon, please.
This honorable court is now in recess until 1 p.m.